Hi! So tonight we're going to go over something exciting and fun. Are you ready? Unions! Ha! You didn't expect me to go that way, did you? No. We're going to cover 4 of the major laws, and we're not going to cover the history, otherwise this would be a 30-minute video. But look it up. It's so cool to see what's going on in our country at that time, and it's also it helps when you know the history because it makes the laws make a little bit more sense and you can connect the pieces. And I'm also going to do my best for 3 of the 4 laws to use both names that they go by, so that way you get more comfortable with hearing them and connecting them together, and know that when I say one thing I mean another, and two terms are the same thing. But it'll help you get comfortable with using both the name of the law and the acts that they go under interchangeably, and so you can recognize it on a test. But we're going to cover the Norris-Laguardia Act of 1932, the National Labor Relations Act, NLRA, or Wagner Act of 1935, the Labor Management Relations Act, LMRA, or Taft-Hartley Act of 1947, and the Labor Management Reporting and Disclosure Act, or the Landrum-Griffin Act of 1959. The first one we're going to go over is the Norris-Laguardia Act of 1932. I'm going in chronological order. It kills me not to go over the history, but here are the following key provisions of this law. It prohibited yellow dog contracts, and those were agreements in which employees promised employers that they would not join unions. This law declared such contracts to be unenforceable in any federal court. It prohibited federal courts from issuing injunctions of any kind against peaceful strikes, boycotts, or picketing when used by a union in connection with a labor dispute. It defined labor disputes to include any disagreement about working conditions. So it prohibited the yellow dog contracts. It prohibited federal courts from issuing injunctions of any kind against peaceful strikes, boycotts, or picketing when used by a union in connection with the labor dispute. And it also defined labor disputes to include any disagreement about working conditions. Then we go up, fast forward 3 years, and we move to the National Labor Relations Act, or the Wagner Act of 1935. This is considered the granddaddy, according to the book, of all labor relation laws in the United States. It initially provided that employees have a right to form unions and negotiate wage and hour issues with employers on behalf of union membership. But specifically, the NLRA, or Wagner Act, grants to employees the right to organize, join unions, and engage in collective bargaining and other concerted activities. Sorry, I struggle with that. It also established the National Labor Relations Board, or the NLRB, which would help define fair labor practices in the following decades. The NLRB has the power to accept and investigate complaints of unfair labor practices by either management or labor unions. It plays a judicial role within an administrative setting. So here are some of the key provisions under this law, which would be the Wagner Act, NLRA, National Labor Relations Act of 1935. The right of workers to organize into unions for collective bargaining. The requirement of employers to bargain in good faith when employees have voted in favor to have a union represent them. Requirement that unions represent all members equally, and covers non-management employees in private industries who are not already covered by the Railway Labor Act. So the 4 key provisions, okay? It's the right of workers to organize into unions for collective bargaining. The requirement of employers to bargain in good faith when employees have voted in favor of a union to represent them. The requirement that unions represent all members equally, and it covers non-management employees in the private industry who are not already covered by the Railway Labor Act. All right, now we're going to move up to 1947 to the Labor Management Relations Act, LMRA, or Taft-Hartley Act. Got it? We got it. So this was the first national legislation that placed controls on unions. It prohibited unfair labor practices by unions and outlaws closed shops, where union membership is required in order to get and keep a job. Employers may not form closed shop agreements within unions. It requires both parties to bargain in good faith and covers non-management employees in the private industry who are not covered by the Railway Labor Act. So basically with the Taft-Hartley Act, closed shops are out, which is good. They're illegal, and closed shops just mean that that union membership is required in order to get your job. There will be jobs out there that require you to join a union after you've been in a job for so much time, but you don't have to join it right away, which is where the closed shops come in. Then we're going to cover our last law, which is the Labor Management Reporting and Disclosure Act. Gosh, that's a mouthful. Or the Landrum-Griffin Act of 1959. So the the Landrum-Griffin Act, the Labor Management Reporting and Disclosure Act of 1959, outlines procedures for redressing internal union problems, protects the rights of union members from corrupt or discriminatory labor unions, and applies to all labor organizations. Specific requirements include the following. Unions must conduct secret elections, the results of which can be reviewed by the U.S. Department of Labor. A Bill of Rights guarantees union members certain rights, including free speech. Convicted felons and members of the Communist Party cannot hold office in unions. Annual financial reporting from unions to the Department of Labor, or DOL, is required. All union officials have a fiduciary responsibility in managing union assets and conducting the business of the union. Union power to place subordinate organizations in trusteeship is limited, and a minimum standards for union disciplinary action against its members are provided. So that is the Labor Management Reporting and Disclosure Act, or the Landrum-Griffin Act of 1959. For the history, full comprehensive picture, just Google it. It's really cool. Definitely look up closed shop, agency shop, union shops, and anything else? Any other shops? No, those are just the three. Check them out, learn them, know them, and just go over what I covered in this video, and you should be good enough to be able to pass your test. All right, well, thanks for watching, and like always, if you have any suggestions or questions, leave a comment below, and I will get back with you. Thanks!